Let us start. Network codes and guidelines. This fabulous, absolutely fascinating topic. What are they? They are European regulations that are directly applicable and enforceable in the member states. What does that mean? That means that exactly on the day when the European Commission adopts them, then they will enter into force at the level of the member states. Hence, the TSOs and the NRAs and other parties that are obliged to respect their provisions can be held liable for non-compliance and non-implementation. Okay, these network codes and guidelines, they deal with electricity cross-border and market integration issues. What does that mean? That means that they are European regulations adopted at the European level, and that they do not hinder the right of the member states in adopting network codes that deal with internal issues of their electricity transmission network. However, it can be argued that, you know, in the end, we're trying to create a system which is encompassing and which covers the entire European Union. Therefore, in the end, this dichotomy and separation between cross-border and national could be a little bit difficult to identify. Also, apart from being European regulations, they are non-legislative acts. What does that mean? That means that, unlike for example, the Regulation 714 from 2009, Directive 72 from 2009, that are considered to be legislative acts because they have been adopted through a procedure that is called ordinary legislative procedure. These ones, the network codes and guidelines, are considered to be non-legislative acts because they are not adopted through the same procedure, but they are adopted through another procedure, which is called the regulatory procedure with scrutiny. In addition, these network codes and guidelines have to be further implemented through measures taken by the member states. What does that mean? That means that all the member states have to equip their legal systems and also have to invest in their engineering development, IT systems, in order to be able to comply with these requirements. Of course, all the network codes and guidelines contain a large period of implementation so that the network codes can actually, or the guidelines can actually be respected and so that all of the TSOs and the NRAs do not fall short of complying with the requirements. As we know, we are all talking about this clean energy package. Hopefully by November 2018 it will be adopted already. The clean energy package clearly establishes another name for these network codes and guidelines. They will be called, they will contain the name Delegated Acts within them. Of course, this was the initial proposal of the European Commission in the clean energy package, but in June 2018, during the trilogues, they're actually trying to talk about them as being implementing acts. This is some sort of a dichotomy which was introduced by the Lisbon Treaty in 2009, but we will talk about it a little bit later. Okay. Let me scroll down. Good. Here. So the idea is that the European Commission creates these network codes and guidelines in order to uniformize the rules. So the main goal is to uniformize the rules applicable and respected by the member states in order to ensure security of electricity supply, affordability of energy, the decarbonization of the system and of the market, and also decentralization. The European Commission does that and has this power of adopting network codes and guidelines through its implementing powers to adopt technical legislation. The third energy package grants the Commission with these type of powers. However, in doing so, the European Commission will be controlled by the member states through these Cometology committees. As I remember, I told you that the network codes and guidelines are adopted through a procedure called regulatory procedure with scrutiny, which means that the European Commission, at the moment when it receives this draft network code, will have to send it to a special committee, which will have to give an opinion, or will give a positive opinion or a negative opinion. I'll continue about it later. So the European Commission has wide powers in what concerns the adoption of these network codes and guidelines. because it is considered to be first and foremost the most important EU institutions, the guardian of the creation of a seamless and well-functioning internal electricity market. That's why the directions of the regulatory, energy regulatory targets start from the European Commission. So the Commission can trigger the development of the network codes following the procedure set out in Article 6 from the electricity regulation. And it can transform a network code into a guideline, and it can adopt a guideline by itself without consulting the stakeholders. So basically, the European Commission, everything starts from there. That's what I would like you to remember from here, that everything starts from the Commission. It is the one that decides what will happen next. So the European Commission initially can start by defining its priorities for the network codes through an annual priority list. According to the Article 6 of Regulation 714, this annual priority list will be done every year by the European Commission. However, according to the modifications, amendments brought by the Clean Energy Package, the Commission will have to issue a priority list every 3 years. Also, one of the reasons might be because most of the network codes and guidelines are already adopted, so then the further directions taken by the European Commission can be a little bit, decided for a longer period of time. And then, so these steps are clearly set out, in Article 6. So the European Commission defines the priorities for the network codes. Then it involves ACER in developing framework guidelines, which will contain the general principles to be followed upon by the ENTSO-E. Then, upon those framework guidelines, ENTSO-E, the European Network for the Cooperation of Transmission System Operators, will have to prepare a draft network code. Then it will submit it back to ACER. ACER will have to give a reasoned opinion on the draft network code and analyze up to what extent the draft network code corresponds to the framework guidelines. If ACER agrees with the draft network code, then in the end it will submit the network code to the European Commission with a letter of recommendation. So in the end, the European Commission will be the one that will adopt this network code or a guideline through the comitology. What is very important to know is that according to Article 6, this adoption of the network codes through this network of networks process ensures consultation of stakeholders. So then when you see all of these steps here in the graph, imagine that every time the agency, ENTSO-E, the Commission, the agency again, will have to consult stakeholders in adopting the draft network codes and taking opinions and adopting the letter of recommendation and etc. So the market is basically involved very much into this entire process. I told you before that these network codes and guidelines are adopted through this comitology procedure, which implies that on the one hand, the European Commission receives the draft network code from ENTSO-E, from ACER, made by ENTSO-E, but with a recommendation from ACER, and then the European Commission will, redraft the text and will send it translated, put it in a nice form, and then send it to the Cometology Committee. This Cometology Committee is composed of representatives of the member states. It's called the Cross-Border Cometology Committee. So it's composed of the representatives of the member states and is chaired by one representative of the Commission. The voting within this will be taken with a qualified majority, and the representative of the Commission is not allowed to vote. The Cometology Committees usually function according to their standard rules of procedure for committees, which define the length of their meetings, how often should they meet, etc. So if the Cometology Committee gives a positive opinion, then the Council and the European Parliament have the power to scrutinize. They will scrutinize and then they will express their opinions, if they want to adopt or not, or they will express their veto according to only three grounds. Those grounds would be if the Commission exceeded its implementing powers, if the draft network code is not compatible with the aims of the Regulation 714 from 2009, or if the draft network code does not respect the principle of proportionality and subsidiarity. Just to make a little bit of a clarification, the principles of proportionality and subsidiarity are fundamental principles of the European Union, on which the European Union is based. Proportionality refers to the content and the form of the Union action, which shall not exceed what is necessary to achieve the objectives set out in its founding treaties. Founding treaties meaning the Treaty of the Functioning of the European Union or the Treaty of the European Community. And the principle of subsidiarity means that the Union shall only act insofar as the objectives of the proposed action cannot be sufficiently achieved by the member states. So then this power, this energy policy entirely, is given to the European Union in order to uniformize the rules that are taking place at the European level, and in order to ensure that the member states comply with them, and then we can actually create in the end this internal electricity market. So this is the part where if the committee issues a positive opinion, then the council can veto on those grounds. There's also the possibility where the Commission issues a negative opinion. So then in this situation the Commission submits the proposal to the Council and forwards it to the European Parliament. The Council can oppose, the Parliament can also oppose. Anyway, if the Council opposes, then the measure will be sent back to the Commission, and the Commission will have to submit an amended proposal or present a new legislative proposal. If the European Parliament scrutinizes it and does not, if it opposes it, it will happen the same. If it does not oppose, then the Council may adopt it. Actually, I think this graph is pretty clear, so for any other further reference, you can use it with trust. Okay, so that was the process of adopting the network codes currently under the third energy package. I'll just mention a little bit the fact that according to the new energy, to the clean energy package, these network codes and guidelines will be adopted and they will be called delegated acts. I will not refer to the implementing acts because the initial, can you hear me? Yeah? Sorry, okay. Sorry, I thought you cannot hear me. So I will not refer to the implementing acts because it was not it was not adopted yet. Sorry, I'm just getting a little bit distracted by all this activity. So the implementing acts have not been decided upon yet, so then we'll just continue talking about delegated acts. What you should remember is that the main difference between delegated acts and this regulatory procedure with scrutiny is that the novelty introduced would be the use of expert groups. And so then the draft network code will go to the European Commission, and then the European Commission will actually use a pool of experts in order to decide on that. So then in this situation, one cannot help but wonder, okay, so is this some sort of a backdoor to cometology, or is this some sort of a new animal, the expert groups, which will ensure a far more wider reach to the stakeholders. What you have to know also is that in this adoption of the delegated acts, the European Commission is obliged to consult stakeholders, and to consult stakeholders through public consultations. Basically, anyone who is interested in the future further network codes and guidelines could very well, submit the comments directly to the European Commission, which I think it's pretty cool. In addition, what is very important is that we have to remember that currently, though, so the European Parliament and the Council are not on equal footing according to the regulatory procedure with scrutiny, but through the delegated acts they will be on equal footing. What does that mean? That means that at the moment that the European Commission drafts the network code, it will send it, finishes to, the draft the network code or guideline, they will send it to the European Parliament and to the Council at the same time. And while doing the drafting or while doing the redrafting of the network code, they will have to accept the exact mentioning will be that the European Commission shall accept experts from the European Parliament and from the Council to its meetings, whereas the European Parliament and the Council may invite experts from the European Commission. This is actually a question that I had in the quizzes, and I hope you got it right. It is a very tiny nuance, but then it's very important to remember this, that shall and may in law have huge differences. So then when you find these words within the regulations or within the directives, you should know that shall means obligatory, whereas may still gives a leeway, whereas to do it or not to do it, it's according to your decision. Okay. So these are the main differences. What you have to remember from this, and it would be really good to leave from this class with, would just be this, that the European Parliament and the Council are on equal footing. They can revoke the delegation at any time, and they can also have unlimited grounds for scrutiny. So within 2 months from the moment when they receive this draft network code from the European Commission, then if they raise no objections, then the draft network code is considered adopted. However, if they do raise objections, they can do it on any grounds. So unlike the regulatory procedure with scrutiny, where they only had 3 grounds for this, now they can invoke pretty much anything, also for the revoking of the delegation. And they are involved in the process just to control the implementing powers of the Commission. Okay. The idea was that the European Commission, the legislator, are trying to make these network codes and guidelines binding, just because the idea is to overcome a regulatory failure. So regulatory failure means that before the third energy package, there was voluntary cooperation measures taken at the European level in order to regulate the market and to create an internal energy market. However, sometimes this regulatory coordination might have, faced some hinders. That's why regulating the matters such as system operation, market operation, demand connection of generators, and etc. are more than welcome at this point. What I think is very important to go back to and to discuss, and it's one of the cores of this presentation, you've heard me talking about network codes and guidelines from the beginning, and probably you are wondering, why am I talking about it just now? Well, I am now talking about it. As I told you before, the network codes and guidelines are both EU regulations. Whenever we talk about the network codes and guidelines that regulate the markets, we refer to them under the umbrella of network codes. That is not wrong. Please remember this is correct. Continue doing so. The difference between the network codes and guidelines lies in very subtle details, which I will explain now. So on the one hand, we have the network codes, which contain their legal basis in Article 6 of the Electricity Regulation. On the other hand, we have the power of the European Commission to adopt guidelines according to Article 18. The topics of the network codes, therefore, will be established in Article 8.6 of the Electricity Regulation. As I told you before, the European Commission needs to develop an annual priority list. So the European Commission first develops the priority list, and then it will start developing, asking ACER to develop framework guidelines according to the topics on that annual priority list. However, when we talk about guidelines, the Commission, under this purpose of ensuring a well-functioning internal energy market, electricity market, can adopt guidelines in pretty much a lot of topics which actually go beyond the annual priority list. You will find all of those topics in Article 18 of the Electricity Regulation. If for the network codes we have the clearly established steps, right? So I showed you the graph with the development. We have ACER, ENTSO-E, the framework guidelines, we have the opinion, etc. For guidelines, we don't have such thing. So for guidelines, for example, in case of the capacity allocation and congestion management guideline, initially the European Commission asked ACER to draft framework guidelines only for the part of capacity allocation and congestion management, whereas the Commission started by itself drafting guidelines regarding the governance of the nominated electricity market operators and of the market coupling in itself. In the end, the Commission merged the two, but the idea is that the Commission actually can start developing guidelines and bypass all of the process with ENTSO-E, ACER, etc., under invoking this higher purpose of ensuring a good functioning of the electricity market. Also, as I said, we have the rules for stakeholders in place. However, for guidelines, it's a little bit more difficult, and it's very unclear how the stakeholders' consultations are actually performed. There is just one mention that in developing guidelines, the European Commission should consult ACER and the ENTSO-E, but I could not find, if you can find something, please help me, any other relations to the involvement of stakeholders. Another difference would be the so-called fixed topics and the flexible topics. The guidelines are envisaged to be legal instruments that are more flexible and that help the regulatory framework be modern and be up to date with what happens in the market. So by fixed topics, I mean the core topics of the transmission system, like connection and requirements for generators, emergency and restoration. You have to have some really clearly established protocols for these types of situations, whereas for the market ones, I think it's easier to modify, to amend, and to try to keep it up in order to correspond to what's happening today. We don't want to have a regulatory framework which is out of date. Another very important continuance and characteristic of the guidelines is that they have to be further implemented through terms, conditions, and methodologies, or through private contracts. This is very important because the terms, conditions, and methodologies have been envisaged to be some sort of continuance by the European Commission of the guidelines, and then it's more of a decentralized lawmaking process or regulatory process, whereas the TSOs come together, they draft the methodology because they are the ones who know the market best, and then they will continue by the approval of the NRAs. Okay, so this being said, I just wanted to say about these network codes and guidelines that the European Commission does this switch. So until now, most of the guidelines have started as being drafted as network codes. However, at some point during methodology, the Commission is the one that does the switch. But there are not so many, there's not so much information on this out there, so then I cannot tell you exactly the moment when this happens, when does the Commission decide that. But what you have to remember is that, yes, during Cometology, the Commission decides to convert these draft network codes into guidelines, especially because of that, the flexibility of these legal instruments. So at the end of 2017, we had these framework guidelines, and these network codes, and as I told you, very important, the implementation through terms, conditions, and methodologies and private contracts. Okay. The terms, conditions, and methodologies are these legal instruments which have been created under a strict process provided for example, Article 9 of the Capacity Allocation and Congestion Management Guideline. So what we need to do is we need to come together as TSOs and develop them. We need to consult upon them. We have to amend them. We need to approve them, adopt, implement, monitor, and enforce. So these are the steps, the life cycle of term, condition, or methodology. Why are they so important? They are very important because they represent a very innovative means of regulating the market, and because the entire process is actually established in the regulation, the CACM regulation, for example. So according to Article 9, if you go to look at Article 9 there, we will see that the process and rules for development, amendment, consultation and approval are there, the topics are there, deadlines are there, the description of the expected impact is there. The TSOs will have to cooperate, they're obliged to cooperate. This also regarding to the question that you have on the poll, I will talk about it later, but the TSOs are under a strict obligation to cooperate according to Article 9 of the CACM guideline. The TSOs are under an obligation to inform ACER. The TSOs are under an obligation to consult stakeholders. They can request amendments, and they have the obligation to amend as well. So if the NRA comes back to the TSOs and asks them to amend, they will have to amend. So the drafting of the terms, conditions, and methodology can be done, on the one hand, by all or several TSOs. And I'm also talking about here about the NEMOs. You also probably talked about them before in the lesson on the capacity allocation and congestion management. The NEMOs are the nominated electricity market operators that deal with market coupling processes in Europe. What I wanted to show you here is that this decentralized decision-making process. So then we come from the idea that we have these regulations at the European level, and then each member state, according to the regions in which they are separated, or at the European level, will come together, the TSOs from the member states, and they will decide on methodologies. So the TSOs can come together at a European level through this forum, which is called AllTSO Forum. Please bear in mind that this is different from ENTSO-E. So the TSOs within ENTSO-E will meet for any other purposes, but also will meet within this forum all TSOs, and they will draft the methodologies. Whereas at the regional level, they will meet on an informal basis. For example, if we talk about the Greek CCR, the Greece and Italian capacity calculation region, we don't know exactly how the relationship between the Greek TSO and the Italian TSO in drafting methodologies takes place. Where do they meet? How often? This type of information is a bit missing. But what we know is that they can meet either through some informal procedures, based on informal procedures, or with the purpose of dealing with other business. They will also meet and try to draft their common methodologies. The idea is that all TSOs or TSOs from a capacity calculation region will meet, they will draft a methodology, and then this methodology will go up to the NRAs, either to the NRAs from the entire European Union, or to their regional NRAs. For example, the methodology on capacity calculation regions has had to be sent to the NRAs from the entire European Union, whereas the methodologies for a capacity calculation, capacity calculation methodology for a certain capacity calculation region will only be sent to the NRAs from that certain capacity calculation region. If we continue to talk about the Greek CCR, then only the Greek and the Italian NRAs will receive that. What will the NRAs do? So the NRAs will receive these draft proposals for methodologies, and they will have to meet. Where do they meet? They meet in this forum, which is called All Energy Regulators or Regional Energy Regulators Forum. This is organized under the auspices of ACER, the Council for the European Energy Regulators. Sorry. So the NRAs meet, and then they will have to each approve the proposal for the methodology. The final document that they will have to conclude after approving on the methodology is called the Framework Agreement of all NRAs, or the Framework Agreement of NRAs from a specific CCR. So then the NRAs have approved, and then after the NRAs have approved and they have concluded this framework agreement, they will have to go back, each of them, to their national countries, and they will have to implement that methodology and the framework agreement through a national individual decision. So usually these national individual decisions taken by the NRAs are acts of administrative law, and can be challenged at the national level. There are also situations where the methodology goes to the NRAs, but the NRAs are unable to reach a common understanding. So then what do we do then? We have ACER for that. So if the Greek and Italian NRA cannot, for example, agree, they will have to refer the matter to ACER. ACER has this prerogative under Article 8 from Regulation 713 from 2009. So if the NRAs cannot agree, or at their joint request on that proposal, they will have to submit it to ACER. ACER is the one who will have to take a decision, and will have to submit its own decision for that of the NRAs and the TSOs. What is very important to know here is the following. ACER, when it receives this proposal from the NRA, ACER will also have the right to amend the proposal from the TSOs without needing to request the submission of a new proposal. So according to a recent judgment of the Board of Appeal of ACER, in the Austrian-German bidding zone case. ACER said that the regulation actually 713 and also the CACM guideline does not contain any provisions that prohibit explicitly ACER's powers to do that, or also the ACER regulation. So then that was a little bit of a leeway that they played with, and they said we have the power to amend, because if we don't amend now the proposal of the TSOs, then the entire process can be hindered, because sending it back to the TSOs will take a lot of time. And then we actually need to decide on the CCRs. However, what is very important about these methodologies is the fact that in some situations the European Commission directly can step in. So remember, I told you the European Commission is really high up, and it's the guardian of the entire internal energy market. The European Commission does not do monitoring on a particular basis. The European Commission is the institution that receives monitoring reports from, you know, ACER, the NRAs, etc. But there are some situations in which the European Commission can step in the case that the TSOs or the NEMOs do not submit the TCMs. If they do not submit the TCMs, the proposal for terms, conditions, or methodologies, the European Commission will have to take the appropriate steps to make possible the adoption of the required TCMs. And why is this so important? Because the terms, conditions, and methodologies are, in the end, an underlying legal act, I'll take that back, an underlying act or agreement between the TSOs and the NRAs that foster the well-functioning of the internal energy market. So then if the TSOs don't respect their obligation of sending this first draft, since they are the technical experts of the market, they will, the European Commission has to actually step in and take some measures. In actually some cases, the European Commission can demand the amendment of the entire guideline. For example, in the case of the CACM. Okay. So the implementation process, I told you a little bit about it. So each of the NRAs, according to these framework agreements concluded at the European level, will have to implement the framework the framework agreement and the proposals for the TCMs, adopted TCMs, through their administrative acts. However, after this implementation, monitoring will be done on 3 layers. So first of all, we have the European Commission as a whole that monitors the implementation of the network codes and guidelines, and hence the implementation of the methodologies. Then we have ENTSO-E, which is the technical expert that does effect monitoring on the harmonization of rules. And then at national, and then we have also ACER, that does effect monitoring as well. And at the national level, we have the NRAs. So the NRAs are the ones that will watch out for these methodologies to be correctly implemented. And what is very important when we talk about law is basically the enforcement of the terms, conditions, and methodologies. So after this methodology has been approved and adopted through a national act, what do we do then? If a TSO does not agree with what another TSO is doing upon a methodology, or if an NRA does not agree with another NRA, etc. So these documents can actually, you know, give rise to all sorts of disputes. I have enlisted them here. And this is what brings me to the polls and to the discussion forum. I didn't address that until now because it was strictly referred to this part of the presentation. So as you probably remembered, I asked you, do you believe that the TSOs are obliged to cooperate with each other? I'm very happy to see that everyone knew that yes, they are obliged to cooperate with each other. That is very good. And we were also talking about the fact that once a methodology is approved, can it be challenged at the European or cross-border level? What I meant by that was whether you believe that there was a means of legal action against a methodology concluded at the regional level or at the European level, at that level, European or regional. If you ask me, I would believe that no, there is none. at this point. And what exists though is a possibility to actually go in front of the national court or in front of the NRA that adopted a methodology within its national jurisdiction and start proceedings there. So this might be a little bit counterintuitive, because if we talk about 28 NRAs, then what do we do if we don't agree with one? Do we have to go to all of the other 27 and start proceedings in front of them or in front of their national courts? Okay. And as you remember, following these poll questions, I asked 4 questions that I thought might be a little bit interesting, you know, for you to start the discussions. So I want to thank very much to the participants, especially to Tim and Nicolo, because they replied and then they gave really good feedback. I'm really happy for that. As I said, what are the legal provisions? When I asked what are the legal provisions under which the TSOs are obliged to amend, I was literally referring to the provision from the regulation, because usually in law it's easier, or it shows that you know where to go to if you know exactly the type of provision that exists there. So yes, the TSOs are obliged to cooperate and to amend under Article 912 of the CACM guideline. When I asked the second question, the TSOs, where do the TSOs meet, right, at the regional level to discuss? Because we know that at an European level they meet in ENTSO-E. Very important though, ENTSO-E will not be held liable for the methodologies that are adopted by the TSOs. So what you have to remember is that ENTSO-E is a different structure, and then the TSOs themselves can be held responsible for anything that happens and goes wrong with the adoption or further implementation of a methodology. These are 2 different structures that you have to remember. ENTSO-E, and then the cooperation between TSOs within ENTSO-E happens under their articles of associations, and then ENTSO-E will not be held liable for any of these matters under the implementation of the network codes or guidelines regarding methodologies. So then I asked another questions. What happens if the TSOs refuse to cooperate? If the TSOs refuse to cooperate and to amend, each NRA will take national action for non-compliance, right? Because they have this obligation under the CACM guideline, and then according to Article 37 of the directive, each NRA will have to ensure that the TSOs respect their legal obligations, and then in the end, if they do not respect that, then the NRA can go to court. And then the 4th question was related to a TSO-TSO dispute. What if the Italian TSO does not agree with the Greek TSO? As I told you before, if that happens, unfortunately, the Italian TSO will have to go to Greece and start legal proceedings in front of the Greek national court first, a national regulator first, because it will act as a dispute settlement court. I mean, and then in the end, the decision of the NRA can be further challenged in front of the courts of appeal. Okay, so I talked to you a little bit about the process at national level. What happens at the European level is that ACER is not intangible. ACER can be very well touched upon and challenged. Therefore, if ACER, in what concerns one of these decisions on methodologies, issues a decision, if the NRAs or the addressees of the decision of ACER do not agree, then they will be able to resort to an appeal in front of ACER's Board of Appeal. If the decision of the Board of Appeal also is not accepted or is not satisfactory for the ones challenging it, challenging the initial decision, then against ACER we can further have recourse in front of the European Court of Justice for different grounds. Under Article 263 judicial review, because ACER is a body of the European Union, so then hence we have legitimacy to any interested party will have legitimacy to start a proceeding under Article 263 in front of the Court of Justice of the European Union. As I told you before, the enforcement challenges of these methodologies are multiple. So then we have to talk about several types of disputes. We talked a little bit about all of them more or less before, but now I will take them case by case. So when we get to this regional or European level and we have these framework agreements, the NRAs have to conclude them to approve the methodology. But the legal nature of the framework agreements is a little bit unclear at this moment. We don't know if they are legally binding on the TSOs. However, what I could understand from the text of these framework agreements is that the NRAs are bound by the text of the framework agreement. So then the NRAs are clearly obliged, according to the text of the framework agreements, to go back to their national country and adopt an act of national law to implement the methodology. So upon this legal obligation of the NRA, then they can actually further start legal proceedings. There's an interesting article in the regulation 72 from 2009, which clearly states that for methodologies adopted under paragraph 12 of Article 37, if any party interested does not agree with the way in which an NRA took a decision related to a methodology, can first of all send a complaint for review to that NRA. So the NRA will have to decide and to issue a decision on the complaint for review, and then the decision of the NRA can be challenged in front of national courts. However, what is very interesting there is that the complaint of review can actually be cumulated with the appeal in front of national courts. So then if you don't like something that an NRA has done, and if you have a legitimate interest, of course, according to a decision on a methodology, you can go to the NRA and ask for a review of its decision, and you can also go to the court at the same time. There's also Article 39, which is very important here, and which is called compliance with the guidelines. So in the situation that an NRA takes a decision on methodologies, which of course relates to the guidelines because they're adopted pursuant to the guidelines, and the decision of the NRA does not comply with the provisions of the guidelines, then any NRA or the European Commission can ask ACER for an opinion. And at the same time, any NRA can directly inform the European Commission if it considers that the decision taken by another NRA is not compliant with the guidelines. So this means that if an NRA, the Greek NRA, asks ACER for an opinion, ACER will have to issue its opinion, and then the Italian NRA will have to actually comply with the opinion. And if the Italian NRA does not comply, then ACER can announce the European Commission. On the other hand, if the NRA, the Greek NRA, directly informs the Commission that it thinks that the Italian NRA might not comply correctly with the provisions of the guidelines, and hence the provisions of a methodology adopted pursuant to the guidelines, then the EC can decide to investigate the case, and Shell is obliged to take a final decision. Through the final decision, the EC might not raise objections, or it might require the NRA to withdraw its decision. The NRA has the obligation to withdraw that decision within 2 months. And the provisions from the article in the directive stop here, but interpreting through the provisions of European law, then we will understand that exceptionally, if the NRA does not withdraw its decision within 2 months, then the European Commission can trigger infringement proceedings against that member state under Article 258 from the Treaty of the Functioning of the European Union. Then we also have the NRA TSO dispute, or the TSO and Array dispute. We talked a little bit about this possibility of the TSO and Array dispute because Article 37.12 applies also to applies also not to the only to the NRAs, but also to the possibility of a TSO having a complaint against a decision taken by an NRA on methodologies. However, if an NRA does not agree with the way in which a TSO fulfills its obligation, then the NRA can impose penalties on the TSOs, and then the NRA can go to court, or if a TSO is not satisfied, it will bring the matter in front of the NRA. The NRA will take a decision. The decision can be challenged in front of the national courts. What is very important here is that if TSO challenges this decision in front of the national court, there might not be any sufficient recourse at the cross-border or European level. So I believe that this is a little bit of a regulatory mislink, because in the end what we would like to create, what the idea is that in case of these types of disputes, there are, you know, prerogatives at the European level, and then the NRAs, or there should be maybe like a direct means of action in which the TSOs can actually protect their rights at a higher level, which encompasses more courts, or which encompasses the European will, and which is not left to the national courts, to the decision of the national courts. Okay, so this was the question that I asked before. Do you think that it would be good to have a specialized course or another means of directly enforcing these TCMs? I'm actually looking forward to listen to your answers either here in the chat or maybe later on the forum. We can continue talking about it. And to finish up this discussion about TCMs, what I would like to tell you is that their legal nature is still uncertain. We cannot actually qualify or define them as being public documents or private. I mean, the European Commission says they're public, but maybe there's a little bit of a private will there, since the TSOs are the only ones who hold the knowledge, the technical knowledge, and they are the only ones who know how to manipulate and work the market. The last part of my presentation refers actually to the implementation of these guidelines through private agreements. I made strict reference to the CACM guideline. What I would like you to know and what I would like you to remember is that the influence and the supervisory powers of the European Commission for the creation of the markets are huge. So the market for energy is of such importance to the European Union that the European Commission can actually intervene and take appropriate steps. This is the explanation from the provision from the regulation, in case these nominated electricity market operators do not comply with their obligation of drafting private agreements. So imagine this crazy thing. If a nominated electricity market operator does not send its agreements to ACER, according to Article 7 from the CACM guideline, agreements on the day-ahead operation of the market, or agreements on the intraday operation of the market, or they do not come up with the all NEMOS cooperation agreement. Also, if the NEMOS do not submit to ACER the agreements between them and third parties being the ones ensuring system supply, communication system, co-location service, etc., then the European Commission can actually step in, and then they can take all appropriate steps in order to ensure that the contracts are in place. On the other hand, also, all these contracts will be actually closely monitored by ACER. However, ACER will not monitor the content of the contracts. ACER will only monitor to see if the market functions well, and should ACER receive any complaints on the content of the contract, then it will inform the European Commission, and maybe they will start an investigation that the content of the actual contracts does not correspond to the ones that they have received as drafts under Article 7. And also, what is very important to know is that these contracts for the operation of the market coupling are concluded and can be complemented by Belgian law. So, according to their provisions within the contract, if something happens and if there are disputes between the NEMOS and third parties, or between a consumer and the NEMO directly, then they can invoke the provisions of the contract, and they can complement their actions with rules of Belgian procedural law. This was everything that I had to say. Thank you very much for now.